Buongiorno a tutti, un saluto a tutti i colleghi che ci ascoltano in diretta streaming sulla piattaforma FAB dell'Ordine degli Avvocati di Roma. L'evento di oggi è uno dei seminari organizzati dalla Conferenza dei Giovani Avvocati insieme all'associazione AIGA ed è anche un evento che con molto piacere viene organizzato qui appunto anche con l'Ordine degli Avvocati, perché affronta un tema che viene ad interessare tanto i giuslavoristi, ma anche chi si interessa di diciamo un'analisi comparata. E quindi parleremo in particolare del lavoro su piattaforme, che sappiamo essere un tema che ha molto interessato la nostra giurisprudenza, il concetto di appunto di eteroorganizzazione in relazione alla subordinazione delle mansioni svolte da questi lavoratori e tra l'altro quello che poi toccherà un po' gli argomenti di oggi è proprio come questo concetto sia stato affrontato in ambito transnazionale, quindi europeo e anche negli Stati Uniti. Quindi io desidero davvero ringraziare i colleghi della Conferenza dei Giovani Avvocati e l'AIGA per aver promosso l'evento di oggi. Ricordo a tutti che è un evento che si terrà in lingua inglese, perché i relatori comunque interverranno senza traduzione nella loro lingua, e però questo vorrei sottolineare anche un po' un valore aggiunto della nostra formazione, perché consente anche da un'altra parte di poter approfondire questi temi direttamente diciamo, coinvolgendo professionisti non soltanto italiani ma anche proprio che vengono da altri stati. E quindi a questo punto ringrazio i colleghi Elia Evangelista e Chiara Palombi, che come segretari della conferenza hanno curato l'evento di oggi. Ringrazio il collega Federico Pisani, che è anche componente della Commissione Lavoro, nonché anche responsabile della Commissione Lavoro dell'AIGA, ma tantissimo ringrazio la collega e già conferenziera dei Giovani Avvocati Giulia Guagliardi, alla quale passo la parola per un indirizzo di saluto per l'AIGA Roma. Grazie a tutti e buon proseguimento dei lavori.
Grazie Cristina e buon pomeriggio a tutti. Porto con molto piacere i saluti di AIGA Roma a questo convegno e mi complimento innanzitutto con i colleghi, direi soprattutto amici Federico Pisani, Chiara Palombi ed Elia Evangelista, per aver organizzato un evento che sicuramente si distingue, diciamo, nel panorama formativo. Questo per la scelta del tema, per aver coinvolto relatori internazionali, per lo svolgimento in lingua straniera, che quindi rende questo evento fruibile anche in un secondo momento ad un bacino più ampio di colleghi, non solo italiani. Non dirò ovviamente nulla rispetto al tema prescelto perché sono penalista, quindi è un tema che conosco poco, ma devo dire che mi incuriosisce particolarmente perché tutto sommato è una realtà con la quale tutti entriamo in contatto in qualche modo di frequente. Mi limito ad osservare però che questo convegno rappresenta un perfetto esempio delle collaborazioni che mi piacciono, essendo coinvolte appunto 3 realtà, AIGA Roma attraverso la Commissione Lavoro coordinata egregiamente dal collega Pisani, la Commissione Lavoro dell'Ordine e la Conferenza Giovani Avvocati. Devo dire che la scelta formativa di AIGA Roma, che in questo senso è sicuramente in linea con l'Ordine, è sempre ispirata all'obiettivo di proporre idee che allargano gli orizzonti attraverso la scelta di temi all'avanguardia con uno sguardo verso il futuro. Sicuramente questo convegno ne rappresenta un fulgido esempio, quindi io vi ringrazio per lo sforzo profuso, che spero possa anche rappresentare un esempio per i colleghi giovani o meno giovani che ci stanno ascoltando. Now I switch briefly to English just to thank our distinguished guests from the US and UK. We are very pleased that you accepted our invitation, and I am sure that everyone will find your presentation very interesting and helpful. Given that the aim of the conference is to give an image of the phenomenon of work provided through digital platforms with a comparative approach. So I hope we will meet again, hopefully in person. You are always welcome in Rome, so thank you again for having joined us today. And now I pass the floor to Elia Evangelista, which will moderate the conference. Thank you.
I will switch to Italian again. Buon pomeriggio a tutti, sono Elio Evangelista, avvocato specializzato in diritto del lavoro e membro della Commissione di diritto del lavoro dell'Ordine degli Avvocati di Roma, se non che segretario della Conferenza dei Giovani Avvocati. È davvero un grande piacere essere qui oggi, aver organizzato questo momento di condivisione. Condivido e sottoscrivo tutto quanto hanno già detto Giulia e Cristina, che ringrazio ancora. Appunto mi sia consentito premettere un breve ringraziamento doveroso ma sicuramente sentito per l'Ordine degli Avvocati di Roma e per AIGA, rappresentata dalla presidentessa Giulia, e sicuramente alla Corte di Cassazione per l'ospitalità, per averci consentito di essere qui in questa bellissima location oggi. Molto in breve introdurrò il tema del nostro incontro oggi, che è quello del lavoro tramite piattaforme digitali. È un tema estremamente attuale e estremamente rilevante. Attuale non solo in ragione di una sentenza molto rilevante del Tribunale di Milano intervenuta a conclusione del 2023 e che sostanzialmente ha disposto la riqualificazione di circa 4.000 rapporti di lavoro fra appunto lavoratori che prestavano la propria attività per una piattaforma digitale di delivery per giunta molto nota, ma anche perché poche settimane fa il Parlamento europeo ha approvato l'ultimo testo della direttiva in materia di organizzazione del diritto per le piattaforme digitali e non. Pertanto abbiamo ritenuto che il tempismo fosse perfetto per proporre questo momento di analisi e soprattutto per proporre un approccio, una chiave di riflessione differente, che è una chiave di riflessione comparata. Abbiamo l'occasione, abbiamo il privilegio di farlo grazie alla partecipazione dei professori Cabrelli ed Harper, rispettivamente dall'Università di Edimburgo e di Boston, e siamo davvero molto felici, insomma, di poter offrire questo momento di riflessione appunto svolta in una chiave comparata e di poterlo fare appunto con degli ospiti tanto prestigiosi. Proprio in ragione della natura spiccatamente internazionale di questo nostro evento oggi, come correttamente anticipato da Cristina, il proseguo di questo incontro si svolgerà in lingua inglese, motivo per il quale per giunta adesso proseguirò appunto il mio breve intervento in lingua inglese. Okay, I'll switch in English right now. First of all, my personal thanks to Professors Cabrelli and Harper for being here, virtually being here today and accepting our invitation. It's such a big pleasure, such a big privilege being here today and having the opportunity to offer this benchmarking analysis thanks to your contribution. So thanks again for this. Our purpose today is to shed some light on a very current and a very crucial legal matter as well, which is the digital platform work. Our idea is to bring on the table a benchmarking analysis between Italy and Europe, and on the one hand, and the US and UK on the other hand. So it's very clear to me that there are plenty of irons in the fire today, and we really can't wait for knuckle down. So I'll just take some minutes to make a very brief introduction concerning like what's going on around Italy and Europe when it comes to platform work. The bottom line when it comes to platform work and digital platform work is that nowadays the subordinate employment is still the front door for accessing to a large number of protections, also when it comes to platform work. The fresh news on a European basis is that on April, the European Parliament approved the final version of the directive, which will be subject to the approval of the Council as well. After the approval of the Council, each member state will have to integrate into their own legislation by the time of 2 years the provisions of the directive. So most importantly, the directive provides for a rebuttable presumption of employment when indicators of controls and direction are triggered. In the last version of the directive, the indicators will have to be determined by each member state separately. Also, the burden of proof lies with the digital platform or with the platform. So it's up to the platform to provide evidence of the fact that there is no employment relationship, which is quite a crucial point, especially with a view to the main purpose of the directive, which is to debunk cases of misclassification. If we have a look outside our borders, we can note that this kind of mechanism is not that far from the ABC test, which was brought up by the California Supreme Court in the Dynamics case and subsequently enacted by the AB5. Also, in the directive, it is provided for right of information for platform workers and the right to have ensured the fact that with reference to every possible crucial decision that is going to have a big impact on the working relationships, a human oversight has to be ensured. As per Italy, very considerable steps have been taken in the last years. According to Italian law, in fact, rules of employment have to be applied to the self-employment relationships every time that these relationships are organized by the platform, including digital platform. The only exception is the case where these relationships are governed by national collective agreements, which are entered into by most representative trade unions. Also, a bundle of rights is in any case granted to the riders, which carry out activity of delivery of goods through platforms, including digital platforms. Once again, this mechanism is quite similar to the one provided in France with the Loi Travail, and also, I guess, not too far from the one provided in California Proposition 22. So, following this point, also, we know that starting from 2020, the case law, especially with reference to digital platforms and riders, ruled that these working relationships have a subordinate employment nature, as the platforms actually exercise direction and control over the riders. As a consequence, in many cases, it was ruled that this working relationship have to be reclassified. And also, as anticipated, it happened in the last part of 2023 by the Court of Milan. So, following this very, very brief introduction, I just want to set off on this journey, which is going to start from UK. I leave the floor to my friend and colleague Federico Pisani, which will provide an introduction of the players and also will moderate this talk. Thanks again for accepting our invitation. Thanks, Federico. What is yours?
Thank you so much, Elia. And inizierò anch'io con pochissime parole in italiano e poi la presentazione dei nostri illustri relatori. Non voglio rubare neanche un minuto alle loro presentazioni. E grazie ancora Elia per questa essenziale panoramica che è funzionale per questo incontro, per capire qual è il punto di partenza e quello d'arrivo. Lo scopo di questo incontro appunto è quello di fare il punto su quindi fornire una panoramica generale dello status sul lavoro tramite, che riguarda, per la disciplina che riguarda il lavoro tramite piattaforme digitali. Purtroppo abbiamo avuto l'intenzione originale era quella di coinvolgere anche il relatore spagnolo che per un imprevisto si è assentato, pertanto inizieremo l'analisi, come giustamente anticipato Elia, da UK con il professor Cabrelli. So, Professor, if you can hear me, I would like to thank you again for your participation. And then we will start with UK, and I would like to leave the stage to Professor Cabrelli from the University of Edinburgh, and who will introduce the employment status of digital platform workers in the UK and the protection afforded to platform workers as a result of the recent legislation entitled Workers' Predictable Terms and Conditions Act 2023, and differences between the regulation of digital platform workers in the UK and the EU. Professor, your word.
Thank you. Can you all hear me sufficiently well? Good, thank you. So first of all, I'd just like to offer my gratitude and thanks to the organisers of the conference and for kindly asking me to present on the position in my country in the United Kingdom, and in particular to Dr. Federico Pisani, who was very kind in ensuring that this would come to fruition. So thank you all. I'll just say a little bit about myself first. So I'm a professor of labour law at the University of Edinburgh here in Scotland in the United Kingdom. I used to be a practicing lawyer specialising in employment law here in Edinburgh. So I have some practical experience. So I have an insight into the concerns of legal practitioners and avvocati, etc. So without further ado, what I will now do is share my screen with you. So hopefully you can now see my screen. If someone could sort of indicate that is the case, I'd be very grateful. Can you see the screen?
Yeah, we can. Thank you.
Good. So I'm now going to begin the presentation. As I said, I'll be focusing on the position of platform workers in the UK. It's a truism, it's an obvious statement to make to the effect that we have now departed from the European Union 3 or 4 years ago. So the position here is slightly different from the EU position, which obviously if we'd remained inside, then it would have had a major influence on the changing our law, so on law reform. What I should probably first do is just explain to you how I'm going to structure my presentation. I have half an hour, so 30 minutes to speak before I hand over to my colleague from Boston. And I'll just give, at the beginning, I'll give some background to the position in the UK regarding platform workers and so on. In the second part of the discussion, I'll move on to the classification issue. Now, there are two classification issues. This is really about focusing on the individual who is a platform worker and the law then asking itself, does that individual meet certain legal requirements? And the first legal requirement is whether there is an employment contract. In essence, that question boils down to, is that individual platform worker an employee? Because employment rights are given to employees in the United Kingdom. The second classification question is, well, if the individual platform worker is not an employee, in other words, there is no contract of employment, are they a worker? So in other words, is there a worker contract, which is obviously something different from an employment contract and being an employee. So focus on worker status. So in terms of classification, the first question is employment status. The second question is worker status. I'll then, in the fourth part of the presentation, look at the Uber case, which has changed the law. So this is a decision from 3 years ago, and it really cuts across the question as to whether an individual who is a platform worker is a worker in terms of the legal significance of that term in English law. And then finally, I'll say a little bit about a piece of legislation that has been introduced and it's not yet in force, so it's not in vigore, I think, as you say in Italian, but it's coming into force in September, so within a few months. Now, before I move on to the introduction, I'm just going to sort of draw out certain elements from some of the discussion that I heard earlier before I started speaking. And I should mention, first of all, that in the UK, there is no specific legislation passed by Parliament which addresses platform workers. So, for example, we don't have a Platform Workers Act of the UK Westminster Parliament. So platform workers in particular have not been the target of legislative attention. So that's the first point. The second point that I'd like to make, a preliminary point, is that unlike the European directive on platform work, so the directive that has been passed and we heard about earlier, there is no presumption, there's no legal presumption in the UK that an individual platform worker is an employee or a worker. Yeah. So whether someone who is engaged working through an app is an employee or a worker, the same usual tests are applied as is the case for any person who is working in a workplace. So there's no legal presumption at all. That's the second point. And the third point is that everything that I say today has to be caveated. Now, what does that mean? Well, it basically means that you need to be slightly wary. You need to be aware of the fact that this year there will be a general election in the United Kingdom, and the election is likely to result in a change of government. And if it does result in a change of government and a different political party, the Labour Party or the Laburisti, as you sometimes say in Italian, if the Laburisti win, then they have said that within the first 100 days of being elected into power, they are going to radically change employment law and labour law in the UK. So we don't really know yet what the shape of that change will be. The information that we have from the Labour Party is quite limited at the moment. But essentially what we do know is that a lot of the rules that I'm about to tell you about today are likely to be modified. And the direction of travel will be in a worker protective direction, because the Labour Party are the party of the worker in the UK and also the party of the trade unions. Okay, so that's just some preliminary points. Now some background. First of all, there are 67 million people who live in the UK. 32.5 million people are in work, so under 50%, slightly under 50%. The rest of the individuals who don't work are either children, obviously, or retired, or we have quite an issue in the UK with millions of people who are long-term ill, so they're not working because of sickness and illness. Now, the number of platform workers in the UK, we don't have an official figure. So we don't have any specific guidance from the government. What we do have are estimates from bodies or organisations that are quite influential in labour relations and labour markets. So we have an organisation called the CIPD, and that is the Chartered Institute for Professional Development. And in the UK, if you work in human resources, so if you're a human resources professional, you will join this organization, the CIPD. So this is like an influential, an important trade body for human resources officials and professionals. And they estimate that there is 500,000 platform workers in the UK. Now, compare that with the Trade Unions Congress, which is the body that is, it's like a sort of trade body for all trade unions. So it's an umbrella organization that all of the trade unions subscribe to. And the TUC, the Trade Unions Congress, instead, they've estimated almost 4.5 million people. So there's a great discrepancy between those two numbers. But what we do know is that the number of platform workers in the UK, it's not insignificant. Whether it's 500,000 or 4.5 million, it's still quite a significant number of individuals being hired through an app, through technological intermediation in the UK. Now, as I said, there's no legal presumption that platform workers are employees or workers. We don't have any specific targeted legislation of platform workers. Therefore, the questions that arise are the same for any individual that is working, where we're trying to decide if they're entitled to employment protection and employment rights or not. So there's really nothing in particular about platform workers that is unique or different. They are simply just another form of worker. And the two questions are, the two classification questions, I should say, are, is the platform worker an employee or are they a worker? Okay. Now, the UK labour market, as I'm sure you're aware, is quite a flexible labour market. It's not quite as supple and flexible as the United States, but it is generally quite laissez-faire. And that, what I mean by that is that if an employer wants to hire labour on a non-standard basis or an atypical basis, so for example, through some means other than a long-term indefinite contract of employment, then there are quite a lot of options available to employers. There's part-time work, there's fixed-term work, there's obviously platform work, there's also 0 hours contracts, which are like they're basically an agreement between an individual and a hirer of their labour that that individual has no guaranteed hours of work. So they don't have a set working pattern or working hours. Instead, there's simply an understanding that one can ask the other to be provided with work or to offer work to the other. So that's why we call them 0 hours, because there's no hours and the relationship is very ad hoc. We also have agency work. So I think you call that in Italian somministrazione. So again, UK market has many agency workers. There's more than 1 million in the UK. So it is quite a flexible labour market. And for that reason, we have lots of cases where these atypical workers often go to an employment tribunal or a court in the UK seeking to argue that they are entitled to employment rights or employment protection. Okay, so what do we mean by the gig economy or platform workers? In the UK, one of the government departments gave, it's not a legal definition, it's simply a definition for guidance purposes of what we mean by platform work or the gig economy. And the government have said that it's a form of employment in which organizations or individuals use an online platform to access other organizations or individuals to solve specific problems or to provide specific services in exchange for payment. So in general, it's a transfer of labor for remuneration, for payment. It's a form of work wage bargain in terms of the basic exchange. And the classic examples in the UK are Uber, the taxi, or Deliveroo, which are extremely visible in my city here in Edinburgh, but also Uber Eats. So that's generally what we understand by platform work in the UK, but it's not a legal, I hasten to add, it's not a legal definition. So as I said, the first classification is really engaging with the classic binary divide between the existence of a contract of employment, which is a situation where an employee is entitled to employment rights and employment protection, and the other situation where the contract is instead a contract for services, which is a commercial contract. So it's where the individual doing the work is a self-employed independent contractor running their own business. We call that the traditional binary distinction or binary dichotomy. And it represents the cornerstone of British labour law, because the position is that if you have an employment contract and you're an employee, then you're entitled to the benefit of employment rights. And in the UK, because we're a common law country, those rights may have two or more different sources. One of the sources is the common laws, which is judge-made law. So some of these employment rights may have particular cases decided by judges as their origin story, or it may be a piece of legislation. So where the employment right and the employment protection, which is given to the employee, has a statute, legislation as its source. Now, where do we find the definition of an employment contract? Well, what we need to do is look at the Employment Rights Act 1996. So this is the main statute, the principal piece of legislation in the UK that governs employment law. And Section 230 tells lawyers what kind of individual is entitled to the benefit of statutory protection, and that is the employee. Now, who is an employee? Well, an employee is an individual, so it can't be a company, and they must have entered into or have been working under a contract of employment. Now, what is a contract of employment? Well, a contract of employment is a contract of service or apprenticeship. And that contract of service can be express or implied, and it doesn't need to be in writing because it can be set up, it can be created orally, so by verbal means. Now, that then begs the question, what is a contract of service? And I'm afraid that the legislation does not tell us. So when Parliament passed the Employment Rights Act 1996, they didn't tell us how we determine whether an individual who is working is an employee, in other words, they have a contract of employment, or whether they're not an employee, in other words, whether they don't have a contract of employment. And the question then is, well, where do we find the rules to classify an individual as an employee or not an employee? And the answer to that is the common law. Now, the common law, as I said, is a distinct source of law from statute. Statute is much more transparent. The common law is a little bit more misty and murky because, in essence, the law is judge-made law. So it's where judges in particular cases have decided what the law is. And because the common law is quite old, it's quite a traditional way of making law in England and Wales and in Scotland. This law is quite ancient. Some of it goes back to the medieval period, where we didn't have employment law as such. We had a law of master and servant. So you have that kind of pre-industrial medieval sense to that kind of language, master and servant, instead of employer and employee. Now, what are the tests? The tests have been updated by case law over a long time, but in essence, the starting point is always a legal decision of a court from 1968, and the decision is ready mixed concrete. And in that case, Mr. Justice McGarry said that there are three key elements to the existence of a contract of employment. First of all, there must be consideration. Secondly, there must be control by the hirer. So to be an employer, the hirer must control the individual. And if there's sufficient control, then the individual has a contract of employment and they are an employee. So control is the second element, and the third element is a bit cryptic and a bit unclear, and it's the point that the contract must be consistent with a contract of service. So all the elements must look like a contract of service. Now, the idea of consideration is now captured by the legal concept of mutuality of obligation. So that idea of consideration in that 1968 case, it has evolved through the case law. So the judges using the common law have evolved, they've developed the law to say, well, consideration is two elements. It's the work wage bargain. So it's the basic exchange of work for payment. But there's a second element, which is that there must be an expectation of ongoing continuity of performance. So what does that mean? Well, it means that if the contract says that an individual, the platform worker, will work for a company, then that simply establishes a work wage bargain. It's not enough to satisfy the mutuality of obligation test, because the second element is missing. And that second element is that the contract must have certain terms which show that there's an expectation of ongoing continuity of performance. So it's this idea of regularity, of futurity, so that in the future there will be ongoing exchanges between the two parties. So it's not a one-off exchange, but there's an anticipation of regular performance. So consideration has evolved into mutuality of obligation, and the marker that I should put down now is that mutuality of obligation is an exclusionary device. So it's a legal test that exists solely to exclude many individuals who are working from the protection of employment law, because it's an essential criterion. So if you have a platform worker and you're trying to determine, is this individual an employee, you must ask, is there sufficient mutuality of obligation in that relationship with the hirer of the labor of the platform worker? And if there is no mutuality of obligation, then there will be no contract of employment, and the platform worker will not legally be treated as an employee. So they do not get the benefit of employment rights. So that's really the way that mutuality of obligation has essentially developed. It's an exclusionary test. It excludes a lot of people. The question is whether the judiciary in the UK, when they sort of developed this idea of consideration into mutuality of obligation in the 1980s and 1990s, did they intend to make it an exclusionary device? That's a question for another day, yeah? But there is a possibility that that was what they had in mind. So the second key criterion is control, which we saw in the 1968 case of Ready Mix Concrete. And the third key criterion is personal service. Again, this is the idea that the individual platform worker must be the person who does the work. So they individually must discharge the obligation to work. So they can't have somebody else do the work on their behalf. That's the crucial point, because many written contracts between platform workers and apps, so the hirer of their labor, will have clauses, so they'll have written provisions in the contract that say that the platform worker can send along someone else, yeah, to do the work. So, for example, Deliveroo in the UK have a clause which says that there's a right to substitute performance. So the Deliveroo worker can say to Deliveroo, I'm not actually going to make that delivery. Instead, I'm going to send the piece of work to a colleague, another Deliveroo driver. And that right to substitute performance is fatal to personal service. In other words, the personal service test is not met. It's not satisfied when there's a clause which gives the platform worker the right of substitution. Yeah. Now, I'll come on to Deliveroo in due course, but again, personal service, like mutuality of obligation, it's a test which is an exclusionary device. It excludes a large amount of platform workers from employment protection. Okay, now there are some other tests, but the three essential criteria are mutuality of obligation, secondly, control, and third, personal service. The problem for platform workers is mutuality of obligation and personal service, particularly personal service, because it's quite straightforward for the app, such as Deliveroo or Uber, through a right of substitution to remove and take away personal service. If there's no personal service, the platform worker is not an employee. There is no contract of employment and there is no entitlement to employment protection. So they receive no protection. Okay. Now, the second classification question is it possible that the platform worker may be a worker? Now, the word worker in English law has a legal meaning. Now, we often use in the English language the word worker or working colloquially, so without any legal significance. But that shouldn't detract from the point that the word worker has a legal meaning. And if you're not an employee, so there's no contract of employment, the platform worker may be a worker. So it's an intermediate category. Yeah. So it sits somewhere between employment and non-employment or the commercial world. So workers are entitled to some employment rights. For example, they're entitled to be paid the minimum wage. They have the right to paid holidays, paid annual leave. They have the right not to be forced to work more than 48 hours in a working week, and so on. So they're not entitled to all employment rights, only some employment rights. But the point is that these employment rights are quite important, such as being paid the minimum wage. So how do we determine if an individual is a worker? Now, again, we have to look at Section 230 of the Employment Rights Act 1996. And it says that the individual platform worker must be engaged on the basis of a contract. So that's the first key element or key test. Secondly, they must be performing a personal service. So again, personal service is a key requirement. And secondly, the app, so the hirer, must not be their client. So the individual must not have the app as a client. In other words, the individual platform worker must not be running a business, because if they were running a business, then the app would be a client or a customer. Yeah. So 3 elements from the wording of Section 230. Number 1, a contract. Number 2, personal service yet again. And secondly, the app must not be the client or the customer of the platform worker. Now, as often happens in the UK, when the judges have to decide an individual case, they sometimes add new requirements, new tests. And that's exactly what they've done here. So in cases, they have said, well, not only must there be a contract personal service and the app must not be the client or customer, but number 4, there must be control. So the app must have a sufficient element of control over the individual. So that concept or that test of control has been added in case law by judges. They've also added mutuality of obligation, but unlike the employment contract, it's simply the requirement for an exchange of services or work for payment. So in other words, the work wage bargain, the basic work wage bargain. Yeah. So this second element that's required for an employment contract, that continuity of performance, is not required in the case of a worker, simply the work wage bargain. Okay, so let's look at the Deliveroo case. So this is a classic platform worker situation. You have a rider on a bicycle who is delivering food to customers of Deliveroo from street to street. Now, in the contracts of the Deliveroo workers, there was a right of substitution. So I explained earlier what a right of substitution is, and it's a right for the platform worker to send an order that they've already accepted to another Deliveroo rider. So they change their mind. They accept a job and say, I will take a pizza to a client of Deliveroo at a particular address in the city, and then they change their mind for one reason or another, and they send that particular job or that instruction to another Deliveroo rider. Now, because of that right of substitution, the United Kingdom Supreme Court, so that's the highest court in the UK, they held that Deliveroo platform workers were not workers. So they're not employees and they're not workers. They can't be an employee and they can't be a worker because there's insufficient personal service. So if we go back to the requirement for personal service, you can see that that's a essential requirement to classify an individual as a worker. But because of the right to replace, a right of replacement, right of substitution, they're not a worker. Now that's controversial. Why is it controversial? Well, we can think of many situations where an employee is still an employee, even though they have the right to ask a colleague to perhaps cover some piece of work for them. But here we have the UK Supreme Court saying, well, if a Deliveroo rider asks another Deliveroo rider to cover a job, to cover for them, then that means that they're not a worker. So they have no employment protection at all, nothing. Okay, now that's quite a sad story for platform workers, what I've said at the end of section 3 there. But it's not the only story, because in general, as I said, it will be difficult for platform workers to obtain the benefit of any employment protection, whether as an employee or a worker. But the Uber case, which was decided 3 years ago, has really changed everything, because it essentially made new law. Again, this is an example of the judges using the common law to change the law and create new law. The Uber case said that there is a purposive approach that must be applied by the judges. Now, I'm just going to skip through the facts of Uber, and I want to move on to the law. Now, the key case in Uber was, what should the courts do when the written contract bears no relation to the actual work that the Uber worker does? So the written terms are essentially a fantasy. They don't reflect the way the individual works in the real world. So should the courts do something to reflect the real world, or should they stick and simply honour the written contract, the terms of the written bargain? Now, Uber says that in certain circumstances, the courts should essentially look at the reality of the situation, so apply the real world rather than simply take the written terms as the only relevant situation. Now, in this case, the courts held that the Uber drivers were heavily controlled by Uber. Now, in this slide and in this slide and in previous slides, I've given you a reason why the courts held that there was sufficient degree of control by the app, by Uber, over the Uber driver. But the point was that Lord Leggett, who was the judge who gave the leading judgment in the UK Supreme Court, he basically said that because of this control and also the existence of a personal service and the fact that the Uber drivers were subordinate and also dependent on Uber, so financially dependent in a subordinate position, then he said where there are these criteria, then the courts should look at the reality of the situation. And in particular, where the purpose of the statutory rights that the Uber driver was claiming were to protect vulnerable and subordinate employees, then the employer, Uber in this case, should not have the right to remove those employment rights simply by clever written drafting by lawyers that they instruct. So the key question here is there control, subordination, dependency, and a personal service on the part of the platform worker? And secondly, is the employer trying to evade statutory employment rights and statutory employment protection? If they are, then the courts will they'll essentially override the written terms of the contract, and they will apply the reality, the real world. Okay, so that purposive approach can ride to the rescue of the platform worker. The fundamental point, though, is that there are certain criteria that must be established to enable the courts to apply this purposive approach, where they essentially classify the relationship based on the real world rather than the written terms. And again, I reiterate these. It's that number one, there must be control, subordination, dependency, and personal service. And secondly, there must be some evidence that the employer usually has used lawyers to write certain terms into the written contract to prevent the individuals from getting or receiving the benefit of employment protection. Okay, so there is some help for platform workers relying on this purposive device, this purposive approach of the common law. Now, there has been some law reform. This should only take me a minute or two. I know I'm over time, so I do apologise. As I said, the legislation is the Workers' Predictable Terms and Conditions Act 2023, coming into force in September. And this provides an atypical worker, such as a 0 hours contract worker or a platform worker, a right to request. So it's a legislative or statutory right to request. So it's a right to ask for more predictable terms and conditions, or more predictable working patterns or practices. Now, the problem for some platform workers is that to be eligible for this statutory right to request, then the platform worker must either be, number one, an employee, in other words, have a contract of employment, or number two, be a worker, in other words, have a worker contract. And as we saw, because of these rights of substitution, which are written into contracts by most employers, that then removes personal service, which means that the platform worker will not be an employee, will not be a worker, unless the purposive approach in Uber can ride to their rescue and confer employment protection on them, where the court looks at the reality and overturns or overrides the written terms of the contract. So for quite a number of platform workers, this legislation is not, I'm afraid, going to be useful. It'll only be where they can use the Uber case to satisfy an employer that the reality should supersede the form. So the content or the substance of the relationship should supersede the form of the written contract that they have. Now, there is a minimum length of service to ask for a more predictable working pattern, and it's 26 weeks. Now, what do we mean by, unpredictability? Well, it's really where the hours of work change quite regularly. So the platform worker never knows from one day to the next how many hours they're going to work and when they're going to work them. So they can't really, they can't plan their life. They can't have a program for their working life. And the fatal flaw, I should say, is that the employer has many reasons it can give to refuse the statutory request that's made by any employee or worker. And as you can see, they're quite extensive. And the main one is the cost involved. So in short, will the 2023 legislation be useful for platform workers? Unfortunately, my conclusion is I doubt it. I really doubt it. So on that note, I will end my presentation. I hope that's given you a flavour of the regulation of platform work in the UK. As you can see, it's not a highly protective system of law at all. In fact, many have argued that it's inadequate and it fails to recognise platform workers. So thank you for your attention, and I hope that was interesting.
Thank you. Thank you so much, Professor, of such detailed and in-depth analysis, even though the time slot for the speech is short to deal with such interesting topic and with a potential vast scope and such important impact in social terms. If I may, I would like to ask you just a couple of questions about your speech. First of all, what is the likely protective effect of the provisions of the Workers' Predictable Terms and Conditions Act 2023? And the second one is, to what extent does the law provide digital platform workers with an expectation of equal treatment with permanent full-time workers?
Thank you very much, Dr. Pisani. It's very, very interesting questions. The first one is that the legislation from 2023 is problematic for platform workers because, number one, they must either be an employee or, number two, a worker. And in practice, in legal practice, the difficulty for them is the right of substitution, this clause, this written clause in the contract that they have signed, which enables them to send a replacement to do the work for them. Now, if they have that right to send for a replacement, it's irrelevant really whether they use it or not. Often the courts look at it and they ask, is it in some way constrained or is it unfettered? If it's unfettered, that means there's no constraint over the ability of the individual platform worker to send along a replacement to do the work. Then that will mean, as far as the courts are concerned, that there's no personal service involved in that contractual relationship. And because there's no personal service, there cannot be a contract of employment and there cannot be a worker contract. So they will not get the benefit of this legislation because they can't establish that they're an employee or they're a worker. The only get out or the get out clause for the platform worker would be to try and rely on the purposive interpretation in the Uber case. And there they would have to show that the reality, the way they actually worked was such that the written terms were just, they were just something that was completely made up. And they were, somehow, Panglossian or just didn't reflect the reality. So in that situation, they might be able to use the purposive approach if there's evidence that the reason the right of substitution exists is that the employer tried to evade employment rights. They're trying to circumvent employment law and to prevent the individual from benefiting from any employment protection. So that would really be the only way. But, in this country, a lot has been made of the Uber case and how it's intensely protective of the working individual, but there are essential conditions on its operation. So, in short, to answer the first question, to what extent will the 2023 legislation be useful for platform workers? Not very, I'm afraid. It's not really going to help them. And secondly, one of the odd features of United Kingdom labour law is that we have some equal treatment protections. Obviously, we have equal treatment for workers with protected characteristics, such as on the basis of race or the basis of disability and so on. But because we were in the European Union, we also had equal treatment rights for certain types of atypical workers, such as part-time workers because of the EU directive, also fixed-term workers because of the EU directive, and agency workers because of the EU directive. But we don't have any equal treatment rights for platform workers at all. And that really goes back to one of the initial points that I made, is that in the UK, there's no recognition in legislation of the existence of platform workers. So we don't have any particular or special legislation devoted to them. So they don't have any equal treatment rights in relation to, for example, standard workers. So if a platform worker is working alongside someone who's employed directly by the app, and the person who's employed directly has more advantageous terms and conditions, the platform worker doesn't have any right to equal treatment, to equalize up, level up their terms and conditions to that of the directly recruited or directly hired employee, I'm afraid. So that's really the answer to your second question. Thank you.
Much, Professor. And now we move to the other side of the ocean, when should be connected Professor Harper from Boston University, who will talk to us about the situation in USA regarding platform workers. Although this is a radically different system from ours, as well as the UK system, of course. But we also know that in the US, the phenomenon is extremely developed, so and equally controversial, of course. So the topic is extremely relevant. Professor Harper, can you hear us?
Yes, can you hear me?
Yep, thank you.
Great. And I also want to thank you, Federico, and your colleagues for inviting me to talk. It's great to see you, Federico, even if only visually. As many of you may know, he was a student at Boston University, where I was a professor, a graduate student there, and I got to know him some while he was there. I was a professor at Boston University Law School for 45 years before my retirement last year. I'm now emeritus. I'm still a co-author on several case books, leading case books, including in labor law, which in the United States is limited to collective bargaining and management labor union relations. Also an employment law book, which covers other topics, which would be under the banner of labor law in Italy. I'm also a co-author of a book on sports law. Probably more relevant to this discussion, I was a reporter for the American Law Institute, which attempts to formulate common law primarily, but other legal topics as well. It's made up prestigious groups of judges and leading practitioners and law professors. And we did a restatement of employment law, on which I was the primary reporter for defining the employment relationship. So this is a topic that has been a concern of mine for a couple of decades, or the general topic of defining the employment relationship has been a concern of mine for a couple decades. I'm not going to provide you statistics or even slides. It hasn't been my practice generally. I apologize for that, but I will stress that the use of platform workers, like the use of part-time workers and agency workers, is quite prevalent in the United States. Uber and Lyft, DoorDash, not Deliveroo so much, but Instacart. There are these large platforms that originated in the United States and have taken over, particularly from regulated taxi cabs, have taken over the personal service transportation industry in the United States. So it is a salient topic, and here, and I can talk about it. Now, talking about American law requires understanding, to me, its many and variant sources. Who decides, to me, is as critical as the standards under which they are deciding. And this is particularly true in this area. Both the federal government and the various state governments in the United States have authority to fashion law. And where there is a conflict between law made by a state and that made by the federal government, the American Constitution renders the federal law supreme, assuming the federal government has constitutional power to legislate in the area, as it does for employment and labor regulations that affect commerce between the states. And that's true for any business really of any substantial size, any private sector business. But federal law can and does allow authority for state law, either by not legislating at all on a topic or by allowing state law to regulate more restrictively. Where Congress intends the federal law to be exclusive, the state law is said to be preempted. This is the case, for instance, for our law governing labor management relations and collective bargaining for private sector businesses, specifically the National Labor Relations Act here. Most federal employment law, however, sets only minimum requirements and allows extra or more restrictive state regulation. Thus, our anti-discrimination laws, paid leave laws, and importantly, our minimum wage law, the Federal Labor Standards Act, and also regulates overtime pay. That allows state laws to demand more businesses that operate to affect interstate commerce. Furthermore, both the federal government and the state governments have three branches: the legislative, executive, and judicial, which each have lawmaking functions that I'll explain. The executive branch is especially important on the federal level in employment law because federal executive agencies are considered by most to have delegated lawmaking power on a topic like defining the difference between employees and independent contractors or businesses. And we have at least three important separate federal agencies that asserted independent authority to define the difference. And the judicial branch is particularly important for defining the employment relationship under American law, because the American legal system, like that of the UK, not surprisingly, given the origins of the United States, is fashioned on a backdrop of common law made by judges. And the common law defined the employment relationship originally in the 19th century as a way to determine whether a business was vicariously liable for the tortious wrongs of those who served it. Now notice, I'm defining the common law from tort law, not from contract law, because contract law is much less important in the United States in the employment area for this particular topic. And the reason is that in the United States, we have the flexibility because we have an assumption that employment is at will unless there is a contract, whether written or oral, for a definite term. This gives us flexibility. But why, in terms of who is employed and whether they have protection for being dismissed or terminated for just cause, unless they have that protection through a contract, through a collective bargaining agreement or an individual contract, they're an employee at will. But as long as they are in a relationship defined as employment, they have the protections that are afforded not through the common law, but afforded, not through contract, but afforded by statute. Okay, so the employment relationship is defined defined through this tort-based principle of that derives from, vicarious liability. But that's important because we are not hung up on problems like mutuality of obligation or personal service, which we consider formalistic doctrines that impede the development of British law in this area. There's no problem with some driver being able to substitute another driver. It's not going to be critical for defining the employment relationship here that for protections offered by employment law. But the question of whether a business should be liable for the tortious wrongs of particular workers is a much different question than whether that business should be regulated in its relationship with these workers. One might argue, and in fact, I have argued, that analysis of the first question can help answer the second. But regardless of whether my analysis is correct, the employment relationship under most state employment law and most federal law as well, according to several important decisions of the U.S. Supreme Court, is supposed to turn on the common law of tort-based vicarious liability. The latter is true, says the U.S. Supreme Court, because most federal statutes, including the Labor Relations Act, which governs collective bargaining, and our anti-discrimination laws, all of them, offer no more than a meaningless circular definition of who is an employee. Typically, it's someone employed by an employer. Meaningless, totally circular. The Supreme Court has assumed that such definitions mean that Congress intended the common law to apply. And that common law, for purposes of vicarious liability, has generally defined an employee as a worker whom a business controls or has the right to control in the manner and means by which the worker renders service to the business. However, common law state courts and the United States Supreme Court both dissatisfied with this somewhat elastic test, particularly for purposes of employment regulation, have elaborated many other factors to consider under a common law test, either as a way to define what is meant by control or to consider in a balance along with control. The result has been a somewhat unpredictable standard. I won't call it misty or mucky, I'll call it malleable, because it's been malleable by individual courts in particular cases, especially those with new factual components, like those of platform workers. The common law factors listed by the U.S. Supreme Court include the hiring party's right to control the manner and means by which the product is accomplished, which is the core old common law test, the skill required, the source of the instrumentalities and tools, the location of the work, the duration of the relationship between the parties, whether the hiring party has the right to assign additional projects to the hired party, the extent of the hired party's discretion over when and how long to work, the method of payment, the hired party's role in hiring and paying assistants, whether the work is part of the regular business of the hiring party, whether the hiring party is in business, the provision of employee benefits, and the tax treatment of the hired party. Look at all those factors, and our internal revenue service, for purposes of tax law, has 20 other factors. So totally unpredictable how these are going to be balanced. The application of these factors to platform workers has not been settled in U.S. courts, but it's not hard to imagine opinions on each side, depending upon the political biases of the decision makers. Though I feel strongly that these workers should be classified as employees under these factors. Now, our Federal Labor Standards Act, our federal minimum wage law, does include a non-circular phrase, quote, suffer or permit to work. That has some, it's not circular, at least, it has potential substantive meaning. And it has been interpreted by courts based on legislative history to express intent to cover a wider group of workers than the common law. These courts have formulated what they call a economics realities test, as opposed to the unreality of the common law, I guess. But this test, too, is a multi-factor balancing test, somewhat different, and at least in application, somewhat more liberal than the multi-factor right to control common law test, but still sufficiently malleable to enable conservative judges to classify platform workers as independent contractors, not subject to minimum wage and overtime wage guarantees. In large part, I think, because again, it's a multi-factor balancing test. Common economic reality test factors include the nature and degree of the employer's control as the manner in which the work is to be performed, that old core common law test, the alleged employee's opportunity for profit or loss, depending upon his managerial skill, which I think should be a critical factor because it involves whether they're operating in an independent business. Third, the alleged employee's investment in equipment or materials required for his task or his employment of workers. I think this also is a very important factor because it relates to whether they're operating independent business. Whether the service rendered requires a special skill, the degree of permanency and duration of the working relationship, the extent to which the service rendered is an integral part of the alleged employer's business, which is, I think, quite relevant for the platform workers. The differences from the right to control balancing factors seem less important to me, however, than the fact that a balancing test affords great discretion to judges who want to resist regulation. I'm particularly sensitive, I think, to the question of who decides and whether their decision-making is constrained by the test. I'm confident that platform workers should be treated as employees under a balance of these factors, even more confident than under the right to control factors. But I am not confident that they would necessarily be by some more conservative judges. Now, a few state Supreme Courts, notably those in California, under the Dynamex case, and Massachusetts, have attempted to formulate a broader and less malleable economics realities test when interpreting the suffer and permit phrase under their own minimum wage laws. This test, which has been alluded to, is called an ABC test. The test, one, places the burden on the hiring entity to establish that the worker is an independent contractor who is not intended to be included within the wage order's coverage. And two, requires the hiring entity, in order to meet this burden, to establish each of the three factors embodied in the ABC test. Not balancing the factors, the hiring party has the burden to establish each of the three factors. A, that the worker is free from the control and direction of the hiring party in connection with the performance of the work, both under the contract performance of the work and in fact, going back to what Professor Corelli talking about the Uber decision in the Uber decision in the UK. And B, number two, that the worker performs work that is outside the usual course of the hiring entity's business, which I think was also litigated in the Uber litigation. And C, that the work is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed. So after the Supreme Court, California Supreme Court in the Dynamex case, adopted this as an interpretation of the suffer and permit standard in the California minimum wage law. This AB test was codified as an amendment to the California statute. The test clearly, in my view, is much less malleable than the multi-factor balancing test developed under the economic reality standards by other courts, let alone the right to control standard balancing test. It at least should be very difficult for a car service platform like Uber or Lyft, or a delivery service company like DoorDash or Deliveroo to meet B and C, if not A as well. Drivers and deliverers are doing work at the core of the hiring party's business, not outside it, as Uber argued in the British Uber case, and they're arguing again in Massachusetts now. And these workers are not engaged in an independent trade, occupation, or business. They're not engaged in the business. They don't have managerial decision-making to hire other workers or to allocate capital. Uber and the other major platform companies have recognized the threat of this test to their business model. They recognize that the AB test would mean they would have to pay much higher wages, including through overtime, and be subject to state laws on paid family leave and sick leave, and also be subject to unemployment redundancy taxation. And if we're ever adopted by federal law to collective bargaining, they thus took advantage of a California law allowing for public initiatives to amend statutes by initiating a ballot proposition to classify platform transportation and delivery workers as independent contractors. Doing this is, part of their business model is to spend millions of dollars to influence local regulation and now state regulation. And so they spent millions of dollars on advertising in a successful effort to sway the vote on the public initiative in California. And they would like to achieve the same exemption in Massachusetts, which actually had already codified the ABC test. They wanted to conduct a public campaign in which they would invest similar massive amounts, but haven't yet been able to get judicial authorization for having such a vote. The companies are instead currently defending a lawsuit brought by right now, lawsuit is ongoing in the trial court, brought by the state of Massachusetts under the ABC test, arguing to satisfy Part B that they are only in the technology business. We're only in the technology business. We're serving the drivers in the right for transportation or delivery business, just as serving the riders. We're not in the transportation or delivery business. Ridiculous, in my view. Meanwhile, there continues to be a political legal debate on the national, federal, executive level that is thought by some, by most, I guess, I'm a dissenter, to be very relevant to the treatment of the platform workers. The debate is an example to me of how the two American political parties are really quite distinct, apart from one now being under the sway of the special corruption and narcissism of Donald Trump. But beyond that, beyond Trump, there's still the Republican Party, traditional Republican Party, that is favorable to management as much as the Conservative Party is in UK, and a Democratic Party, which is favorable to labor and workers as much as the Labour Party in the UK, a center-right and a center-left party. So the U.S. Department of Labor is responsible for implementation and enforcement of the Minimum Wage Fair Labor Standards Act. The Republican Trump department promulgated a rule that modified the economic realities test to make a finding of employee status less likely. But the Democratic Biden department suspended this rule's implementation, and earlier this year finalized a new rule that returned to the traditional economic realities test. Similarly, the Democratic majority on the Biden-appointed NLRB, responsible for implementing the NLRA, decided a case last spring that overturned a decision of the Trump-appointed Republican board that was intended to make it easier to find independent contractor status. To me, given the Supreme Court's directive to the Labor Board to apply the court's common law standard when determining which private sector workers are protected by the Labor Relations Act, I am not sure that the views of the Labor Board, whether appointed by a Democratic or Republican president, should matter. It seems to me it's the courts that should be able to set and apply the common law. Indeed, I'm not sure any of the tests set forth in these political moves between Republican and Democratic administrations make a difference. If they do, it may be because management side and employee side lawyers claim that they do through a lot of lobbying, litigation, and polarization, political polarization, and thereby convince judges that they must react differently depending upon whether the Republican or Democratic rules enforced. To me, what would be more clearly would make a difference is a codification of a strong rule like the ABC test, and on a national as well as a state level here in the United States. And I want to say, I also think the European directive proposal would make a difference, because this proposal does not call for balancing those 5 general factors, but I think specifies them in a meaningful way, and then says any 2 can shift a burden onto the hiring party to prove that there's not an employment relationship. I think this approach would be able to constrain discretionary decision making better than would a balancing test like those applied in the U.S. That merely calls for a consideration of these factors. My only problem is, although I am very process oriented, and I think the shifting of the burden here is very significant, as it is under the ABC test. My only problem is it then says that the hiring party can carry a burden to show that there's not an employment relationship. And I don't see in the directive any standard, any set standard for what the hiring party would have to show. I mean, what is the ultimate substantive standard for whether there is an employment relationship? I would be very interested in what is contemplated there. Is that just up to the individual members of the European Union? Okay, well, that's all I intended to say. I think I stayed within my time, even maybe the first time I was given, and I'm open to questions at this point. Thank you.
This was really extremely interesting, especially from our perspective, even if we are not governed by common law, but the relationship between case law and law here in Spain as well are such developments are not so far from what is happening in the US. Just a couple of questions, if you could provide us with a brief answer. First of all, do you think that there should be a special coverage rule for platform workers, or should this rule apply generally for all formal work, for all forms of work? And the second one is, just the second one is the proposed directives approach superior to that of the American multi-factor test and ABC test? Thank you.
Well, I think that the question of whether there should be a special rule for platform workers is both a legal question, a formal legal question, conceptual question, and a political question. I think that as a formal conceptual legal matter, there really is no reason why there should be a special test. The same considerations, the same issues come to the fore for all workers. And I think that it's more persuasive to businesses and to lawyers that there be consistent standards. There's just no rational. I would be interested in what Professor Corelli says, but I don't, or what you all say, but I just don't see why there should be any rationally a distinction. However, politically, it may be helpful to have special standards because this has become a particular political issue. And as Professor Corelli referred to, there have been special directives for other parts of the workforce. And it may be easier to take this approach for just this limited group of workers. And if it works for them, maybe it's helpful then for other workers. It can be a basis for expanding the rule for non-platform workers. So that's how I would respond to the first question. Now, the other question is, do I think this approach is better than the American approach? Well, I think I said in my talk that I think that it's better than the American multi-factor balancing test, because I think it limits the discretion for two reasons. One, I think it limits the discretion of decision makers, judges, and is more predictable. And second, I think that the reversing of the burden of proof is very helpful for worker protection and justifiable because the hiring party has more information and is in a better position to present that information in court about the actual operation of their business. And it really, at base, comes down to the operation, the nature and the operation of the business as to whether there is an employment relationship. So I think for those two reasons, it's the European directive is superior to the American balancing test. And I think to the British test as well, the UK test as well, in their statutes. Whether it's better than ABC test, I'm not as convinced that it's better than the ABC test. I think the ABC test parts B and C both capture something, and they have an ultimate standard, which again, it seems to me that the European directive proposal does not. It just reverses the burden if two things are met, which they certainly would be in the case of platform workers, typically. But then what's the ultimate standard that the hiring party may be able to prove with its burden of proof? I would like enlightenment on that question again. Let me ask you guys how that is intended to develop. Thank you.
Thank you. Thank you so much, Professor. Let me say, I know we are tight on times, but let me just say that we're particularly glad to have your speech and Professor Cabrelli's speech. We are honored to have the opportunity to listen your perspective, and we believe that, I think I can speak from everyone here, that this kind of conference proves that even though we are talking about radically different legal orders, the main issues remain the same, especially when it comes to outline the limits of subordination and platform workers. On this point, I would like to leave the floor to my colleague and friend Chiara Palombi for the conclusion. Thank you again, Professor.
E salve a tutti, anche io comincio con 2 parole in italiano. Volevo veramente ringraziare l'Ordine degli Avvocati per averci dato questa possibilità di organizzare appunto un convegno di respiro internazionale, e anche i miei colleghi con cui ho avuto il piacere di organizzarlo, e Giulia appunto Guagliardi per la presenza, la partecipazione e il supporto costante anche di AIGA Roma. E appunto anch'io sono un avvocato specializzato in diritto del lavoro, quindi per me è stato veramente interessante approfondire e avere questo argomento anche da un punto di vista comparatistico, e avere insights anche da parte di professori d'oltreoceano e inglesi. Ora concluderei appunto tornando all'inglese, vista la natura e il respiro internazionale del convegno. Well, first of all, I really want to express my gratitude to the speakers of today, Professor Cabrelli and Harper. Really thank you for having accepted our invitation and having shared with us these useful insights and brilliant insights on the matter of the digital platform workers in your respective countries. So we really appreciate that. And I'm really glad that we managed to organize this conference, since I must say that a comparative approach to legal issues has become essential in our profession, since the achievement of one country can be the benchmark from other countries on common issues, and of course enhance fruitful solutions. This international comparative methodology, it's indeed the ground for new laws as well as of national judgments, given the global extent of the contemporary legal issues due, of course, to the internationalization of commercial exchanges and business relationships. In fact, the matter of digital platform workers, it is indeed, as we have seen also today, as a global issue, considered that the biggest companies, digital platform on the market that we have referred to also today, such as Uber, Deliveroo, Just Eat, etc., can be found all over the world. Only in Europe, according to European authorities, this phenomenon concerns more than 28 million workers, number that is expected to increase up to 43 million next year. And we have heard before from the speech of Professor Cabrelli that only in UK we are speaking about 4 million workers, more or less. So we are speaking about really big, huge numbers. And so the dimension of the issues influenced the approach of lawmakers and judges. And I want to bring this example because one of the most recent judgments on this subject, also Elia before mentioned this important judgment issued by the Court of Milan last September in 2023 and confirmed in last March in 2024, regarding 4,000 terminations implemented by Uber Eats Italy after the decision of the company of shutting down here in Italy, in the country. Well, I'm mentioning this judgment since it is really interesting to notice as the judge, the court, before arriving at their final decision, started from the definition of worker according not to the Italian national law, but European treaties. Then he makes an analysis of case law on this particular matter in other European countries, if I'm not wrong, France, Spain, and also UK. So this by reading this sentence, one can realize that the clear importance for lawyers of being aware of what happens in other countries. So also for this reason, I think that this conference was really appropriate and useful for our profession. Given that also the direction of the judges is this one, including in their judgment, in their reasoning, also the comparison of what happens in neighbors countries. Yeah. Of course, the judgment before Elia already mentioned, it was very interesting since basically the judge deemed as mandatory the procedure, the information and consultation procedure that in Italy has to be implemented when the company decides to dismiss more than 5 people, and in this case were more than 4,000 workers. So it was a very important judgment, and that states strongly what is the direction of the judges right now. Furthermore, let me say that thanks also to this very interesting discussion, I can state that a lot have been done to improve the condition of riders and digital platform workers, because I remember that exactly 5 years ago, in occasion of an international conference organized by the European Young Bar Association, that I also represent today, an international organization of young lawyers, that we organized here in the Corte di Cassazione. Well, I spoke about the same topic. And 5 years ago then, and I remember that 5 years ago, I had more question marks than answers, I must say. And looking at today Italian laws, hearing the professor, I must say that things have been a little bit changed, and a lot of improvement have been done on the matter. And of course, I think that something more, it is brought also by this new directive, of course. And we will see more by the implementation of the European directive that we were discussing about. And if I can add my personal comment about it, I think that what will be a concrete impact in the litigation after the implementation of the directive, it's the reversal of the burden of proof on the employer. It means that it will be up to the digital platform to prove that there is no employment relationship, while, as we know, according to the Italian law, the burden of proof in this kind of litigation is on the worker who claims to be an employee. So it means a complete different way of building case for employers, lawyers, I must say. However, let's say that, as I was saying from the last time that I talked about this, the qualification of digital platform workers is still a hot topic, since it is a concrete example of law trying to adapt to challenges posed by new technologies. And I must say that sometimes it can be easier to make the work digital than to guarantee that the work is dignified too. So probably the best solution, of course, it would be to find a balance between business models and dignified work and minimum guarantees for workers. So again, really thank you to the professors and to my colleagues. I don't know if you want to add something before we finish.
No, thank you again. Also, by my side, I mean, it was like a great meeting, a very enriching opportunity to know more about, UK, about US, about the general change which is happening. We are part of this change, so I'm definitely happy about being more aware of this right now. Thank you again for accepting our invitation and for taking part of it. Jacob?
Thank you. I would like to thank you again, the professors, and I hope to visit you again at Boston University and Edinburgh. And I had the opportunity to study there during my PhD course, and I would like I really would like to visit you again. Thank you again.
Thank you.